Let's remove this. Okay, we're going to get started in just 1 second. We just have two or three of your colleagues that we're going to give just an extra minute or so to. Ah, voila, showing it right now. There we go. All right. Okay, so we'll add, I think we're only missing one person. We'll add them as they show. Welcome back. Critical Race Theory Seminar, Class 4, February 10th, 2021. All right, I am going to apologize in advance because I get into this stuff. So the amount of stuff that I have that I intended to go over is just clearly not going to be fit within the next hour and 45 minutes. Um, what's probably going to happen, I predict that we're not going to be able to give lat crit the justice it deserves if I do that. So we're going to introduce it today and spend a lot more time on it next week. So, and I think that's also appropriate because I think the next readings are even more directly on the expansion of critical race theory towards other subordinated groups other than Black people, and also introducing intersectionality. So I think introducing lat crit, focusing on lat crit, and on the one hand, and intersectionality as well next week can really bring home how critical race theory has expanded from just a concern about the so-called black-white paradigm towards almost every conceivable group that that has a plausible claim that the system is subordinating them in some particular fashion. And I believe critical race theory, I believe critical theory can accommodate that. And as a law and economics person, I think there are constructs that can accommodate or allow for the law, or at least the judiciary, to see and deal with subordination regardless of the group. Um, I'm every week I choose another position so that my internet doesn't get all fuzzy. Hopefully it'll be better this time. If feel free to raise your hand, chat, or whatever if whatever something becomes clear or you need me to repeat something. So before we get started, let's review, or in this sense of review, what are your questions, comments, concerns that of anything that we've gone over, any terminology that you want me to go over, any statement that I made that made you scratch your head and say, I don't think that's right. Um, Anything on your mind from the last couple weeks. All right. I emailed out a class review, or like a little 40-minute review yesterday for those that want to go over the previous class. I did make sure that I pressed the record button at the beginning of this class so that you can see it in the whole, so I don't have to necessarily do a review. This particular class, though, you may want me to do something to shorten it, because again, once we get started, uh, there's a lot. And again, and this is a seminar class, so it's meant to wash over you. right? It's not so much that you have to come out of this class with the understanding of critical race theory that I have. It is my job to just try to get as much of what it is and how it works in front of you, so that you can embrace what you might embrace, utilize what you want to utilize, or reject what you don't think is appropriate. And hopefully, um, through a rejection of something I say, it inspires you to write something, or investigate or study something to advance the topic, to bring some clarity to the issues. Teach me. Current events, things that have gone on in the last week, or at least coming up. Just wanted to let you know, and I'll probably send it around. Jelani Cobb is a very talented writer on race and justice and what have you. I believe American University's library has some type of series. I'm sure I'll find it and send it around to you guys tomorrow, for tomorrow. It's not mandatory, anything like that, just somebody that I happen to know is a very, very, very good speaker on the contemporary issues relating to racial justice. I am very immersed in legal theory. This we could do a lot more of current events. We could talk more about what's happening, what happened at the Capitol. Um, it's when we talk about this prosecution of the conspirators, or if we talk about the impeachment, I mean, it's ripe for a discussion about disproportionate and selective law enforcement along racial lines in comparison to BLM and whatnot. And definitely, if folks have comments or commentary on that, that'd be great. I actually, but my style is, as much as I'm concerned about those things, as much as I think those things are interesting, I love the fact that we have speaker series to talk about those things. Whereas in class, I just tend to be a little more doctrinal. Sorry. Um, but also when it comes to current events, I just don't want to bring things to your mention. I thought something was very interesting. I ran into a blurb or an article about a professor who is entirely against critical race theory at Cornell University's law school. I thought that was very interesting. And he even has created uh, a website called criticalrace.org, um, that is designed to track all courses in higher education about dealing with critical race theory, to warn parents away from them, to warn parents that their children are going to be indoctrinated by these harmful theories and I guess Svengali like professors. Um, and I just think it was interesting. I hope I didn't. I just checked just to make sure the website was active. I didn't glance through it. I hope I made it. Um, as you know, if I'm hip hop, so if you ain't got no haters, you ain't popping, is you? Right? You got to be a player to be hated. I really hope that I made the list. But if we're going to be broad, right? We want to hit all sides. If you're interested in I assume since he's at Cornell University, I assume it's a scholarly and intelligent critique of critical race theory. So have at it for those that want to check it out. I am going to offer, again, this class is about, or at least chapter, what is that? Was it three? Chapter three of Professor Bridges' work was about the critiques of critical race theory, and I'm going to present a boatload of them from my perspective. And well, not, I'm going to categorize them in different genres and also include my perspectives. And that's actually what's probably going to take so long that we don't even get to lat crit, because there's so many criticisms that we can levy. None of them are silver bullets or damning in any sense. They all have a return volley. Um, but again, if we want to speak on it and be prepared to get into discussions and arguments about it, be good to know what type of stuff is going to get thrown at you. Another thing currently, I guess, is within the federal government, right? That prior to leaving office, reluctantly, President Trump signed an executive order banning critical race theory and diversity training within the federal government. And now, within his first days in office, I believe President Biden has written an executive order restoring those programs, or at least reversing the ban on them. And it's really, we talk about laws, we talk about the judiciary and judges and how they operate. One of the open spaces of critical theory and critical race theory is administrative government, or basic administrative law, right? And how the executive branch uh, perpetuates or can fight racism, right? When it comes to scholarship and research and what have you, that is probably, that branch of government is least discussed when it comes to critical race theory. Um, and we, and I think these executive orders really highlight the amount of executive power the president has when it comes to race, because you have $1 trillion budget that's approved by Congress, but it is the president that decides that we spend that money here or we don't spend that money there. And Heckler versus Cheney, for those, any of those of you that have already had administrative law, if you remember the case of Heckler versus Cheney, those type of budgetary decisions are absolutely unreviewable by the judiciary, right? That the judiciary, through separation of powers, will not second guess the budgetary priorities of the executive branch. And therefore, issues of hiring, contracting, funding, um, you can do a lot of good or you can do a lot of harm. Um, if there's anybody, we're going to talk about final projects and final exams in just 2 seconds, but that's the type of issue I would love if anybody wanted to tackle that type of project and gather those executive orders and teach me, right? Teach yourself, teach the class, right? Those type of issues are what we do as critical race theorists, is find the legal text that is out there and just examine whether or not the extent to which they produce unjust, unfair results. So let's take a couple minutes to talk about the final project, final exam. I think I mentioned at the very first class, but I think right now it's a good time to remind you, and it's also in the syllabus. My intent as far as your final project or whatever, or your final assessment, um, is I would prefer a writing project, what I would call an abstract. I think it is something short of a paper. Although, if you want to do a traditional paper, I am all for it. I love papers. I love research, love reading articles and all that other good stuff. So, especially if you want to get published, that gets me hyped. So, if you want to really research something and really write it up and get it published, and 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 understand how much publishing is materially valuable to you. When you get into the legal profession, you're still selling yourself. And the fact that you publish something is shorthand information on your resume that you have some type of expertise, that you know more about some discrete item than anybody else, and that you're willing to go that deep to be more in tune or more educated about a specific topic than everyone else. And if you continue to develop that expertise, we're going to, as a firm or as a nonprofit, we're going to find a way to exploit that, right? So that is how we connect, or we can connect publishing to paying off them student loans eventually, right? However, that is not what, you don't have to go that far to get a good grade in this class. Um, an abstract to me is something short of that type of paper. However, still follows that structure. We still want to know what there's an issue. We still want to know what rules or laws or text is at play. And I would prefer that you use the rubric that we're developing here about examining the text of it, examining the intent of it, examining the purposes of it, and then after that, perhaps a broader discussion of things that were outside the legislature's expectations, right? And it can be on any particular issue that's on your heart, on your mind, and I can also help you as far as identifying a particular issue. If you just have a particular group you're concerned about, we can do preliminary research and find those issues that may interest you and inspire you to go deeper. One thing that's great about scholarship is you may be able to put something in a different perspective, but there's almost nothing that you can think of that hasn't already been dealt with somehow, some way, right? And one of the beautiful things about scholarship is when you find a really good piece that speaks to you, then going into those footnotes and finding all the people that taught that author, right? So that those the footnotes of a really good paper that you like can be that roadmap to really digging deeply into a subject area that you have a that you want to explore. And again, teach me about it, right? I have my own little cubbyhole corner of tax and hip hop and whatnot of critical race theory. And I am not an expert on the rest of the field. I am cognizant of a lot of the issues, but to the extent you teach me in detail about some issue that is about, that's lawyering, right? That's lawyering. Lawyering is teaching. Um, Now, that said, I have been thinking about if certain people have a strong aversion and prefer a written final, traditional final exam, I do believe I can accommodate that. Although um, and I'm sure when I taught tax and administrative law, I'm here to tell you a lot of people did not appreciate my final exams. But this is a seminar class, so I probably would not be as strict. But my preference would be for the abstract. My preference is for the writing project. However, if you have if certain folks have a very strong preference for a final exam, I can take that into consideration. I would like for you all to email me or contact me by next week to at least give me a sense of whether you want to do the writing project, whether you want to do a written final exam. If you want to do the writing project, the more detail, the better. Or if you just have a particular group that you want to explore and would like even some help as to identifying loads of different issues to choose from. Again, I don't know, no matter what group you represent, there's a cornucopia of issues that you can explore. So so let's aim for an email from each of you this week leading up to next week about whether we're doing a writing project, whether you have a preference for a final exam, and then for those that are doing the writing project, yeah, if you want to identify um, um, a direction that you're headed towards. Some of you have already started, as a matter of fact, and I applaud you for thinking about these things. I assume, some of you may have taken CRT just because it fits your schedule and because you like watch over you, and that's cool too. Some of you may already have had experience and taking classes that led up to your taking this particular class. So wherever you're at, we can work with it. We can work with it. All right. Questions, comments, concerns?
Um,
Yep.
one question and then one update for you.
Mm-hmm.
I did pull up the criticalrace.org website
Mm-hmm.
and it was updated as of February 1st. And unfortunately, you're not on it yet.
Oh, see?
But I will gladly, for extra credit on my final project, submit you in the class. Um,
Well, that's
but
I.
one thing, oh, just I was gonna say one thing that I thought was interesting. I want to like read this website more because it's kind of humorous in a way.
Mhm.
But even though it's calling out critical race theory, it still manages to say that critical race theory started with European Marxism. And I'm like, wow,
Yeah.
wow,
Yeah. Yes.
there's a
Yes.
lot to unpack there. But I did have one question about the writing project.
Yes. Yes.
Would you be able to meet with us, like if we have like a couple of ideas? Because um, a lot of the topical areas that I'm interested in pertain to indigenous rights and
Hmm.
sovereignty.
Okay.
But as a non-native person,
Yeah.
it's not necessarily my place to be writing in this space. And so I want to be mindful
Hmm.
and in recognition of like, should I be picking something else, which I'm glad to, but if there's a way to do that, is that something that we can talk, like if other people in the class have
Absolutely.
similar questions?
Oh, absolutely, absolutely. So let me also add that when you contact me this week, yeah, you can, if you already have your ideas and you just want to send me an email, that's great. If you want to talk about it, yeah, we can set up one-on-one conferences or whatever, and explore. Um, and I think even if I'm not, again, I'm cognizant of a lot of the issues, and I'm also cognizant of a lot of the scholars that are in each particular area. So I I don't think anyone is an interloper on anyone else's area because of the fact that I do believe, again, the job of a lawyer is to teach. So if a client came to our law firm and wanted to know, or our nonprofit, or whatever the case may be, and wanted to us to do a, a gobs of research on a particular issue relating to race, indigenous rights, or whatever, we're going to complete that task, right? We're going to do our best to teach ourselves and teach that client. And of course, being respectful of the fact that maybe it is outside of our individual perspectives and that we are taking an outsider view. But the task of a lawyer, in my view, is to delve into their client, whomever they are, and what's the word? An attorney is an agent, right? I have to be you outside of you, right? And so that's impossible to do, and yet we try to do it anyway, right? So I definitely welcome that discussion. I'm already thinking of Gerald Torres and all types of people that we can put you whose scholarship we can put you in tune with and set you off running. So great question, very
Thank you.
fantastic question. More, please, more comments, concerns, questions. Okay, so well, let's look back. I see my internet connection is unstable. So let's look back. Last week, um, we were uh, we were talking about Comcast versus National Association of African American Owned Media as an example of a case where that is criticizable as far as its treatment of race and is also consistent in a certain way with interest convergence theory that the standard is higher to prove racism when it comes to commercial contracting than it is with employment discrimination. Um, we were able to touch on or at least you got me to hear give a long spiel about how Gorsuch applied textualism or said he was applying textualism, but it didn't really look like textualism to me, or at least the version that Justice Scalia and Clarence Thomas say that they're performing. Um, and using that as a way to say they had already made their decision up in their minds and that the legal writing process or the opinion writing process is kind of a cover. We looked at Justice Ginsburg's concurrence of a very beautiful example of the use of purpose, right? Of her investigating and presenting the legislative history of the 1866 statute, of presenting the different amendments and interpretations over the years of the statute and suggesting that those things um, revealed a broader purpose than the text or Gorsuch and the rest were willing to concede. And also my argument that uh, Gorsuch's mistake with textualism also reveals his dynamism that most people don't consider dynamism. They read the text against a rule that was set up for judicial convenience, right? There was already a rule that the but for test is a presumption somewhere. And the text was read to see, did the text give them an exception? Did it offer an exception to their presumptive rule? So if the rule is judicial convenience, then that's a consequence that's untethered to any legislative expectation. So, in other words, did Congress tell them that that's where in the statute did Congress tell them that they should be worried about their own convenience versus producing justice? So, uh, where we stopped off and where we weren't able to continue is Derek Bell's kind of response to that case that he wrote 20, 30 years before the case, right? In my view, Derek Bell's Racial Preference Licensing Act, which was on the menu for last week, anticipates Comcast versus the Byron Allen case almost perfect, right? The, so his argument about racial realism, about the idea that the Supreme Court is only protecting the illusion of inclusion, that it's not going to actually vindicate um, civil rights in a meaningful way. He doesn't say that to say give up. He says that to say perhaps there is a different approach that we should use. If you can't count on the courts, then maybe there should be something different. And so he offered in Faces at the Bottom of the Well a very provocative proposal called the Racial Preference Licensing Act. And again, for those of us that when I first picked up the book, this was so outside of the norm for a professor to argue, maybe we should let people be racist if they paid a fee. And that fee then redistributed to programs that benefit Black people. Kiara Bridges criticizes Derek Bell's approach to Brown versus Board of Education and school integration. Derek Bell says we weren't necessarily looking for integration. We were actually looking for either better schools in our neighborhoods or inclusion in mainstream schools, but that the funders and the higher ups decided that it had to be all about integration. And he says that again made the mistake that Byron Allen case makes, that it takes the illusion of inclusion and or at least let me not call it an illusion or the drive for inclusion and makes it more important than actual material benefits. And so in this particular case, is it better to have lawsuits uh, that charge racial discrimination? There was a Black doctor who died of COVID, and she complained through video, and it came viral about her treatment in the hospital and how she was treated. However, under Comcast versus NAAOM, she would have to prove that her treatment would have been different but for her race. What evidence would she have to conclusively prove that it wasn't because she was belligerent, it wasn't because she was in the wrong neighborhood or whatever, that proved conclusively, but that she received poor treatment but for her race, or she would have received better treatment but for her race? What proof could she offer? Ms. Ramirez?
Yeah, Professor, I just had a question kind of about that, and it kind of leads to what our reading was for tonight, but so this idea that I feel like unless you can tell stories and like the concept of like understanding that like discrimination now, I mean, nobody wants to be racist, right?
Mhm.
Like it's, nobody wants to be a Karen. Everybody gets videoed now. Like it's frowned upon, right?
Yep.
But so there's not a lot of overt racism, and so it's really that standard like but for her race. I mean, we see it in like housing discrimination, employment
Right.
discrimination, but like I mean, there's just like a gut feeling, and and you also know that the systems that have been established in the reading they were talking about, like just as far as like standards and qualifications and resources that are provided to white candidates versus black and brown candidates, like we see that happening. So like how do you I guess like how do you meet that but for standard when but there's nothing, like there's, I mean, they're not overtly discriminating, they kind of just do it with a smile and like a
Pretext.
handshake. um
Yeah.
how would I guess how would you do that?
Well, that is the issue, and that is what Byron Allen or that case was about, and that is why it's criticized from the CRT camp. The argument that uh, the but-for test instead of the motivating factors test. The motivating factors test allows a great deal of evidence, right? It allows us to paint the picture of the defendant as a general so-called racist, right? That this person or this entity or institution is not within the norms of this country and should be sanctioned, even if I can't prove that my particular care or contract or treatment was solely bad because of race. I can prove that through emails, through statements or whatnot, that this person has racial animus on the brain or within the institution. The but for test says is more consistent, and let me be conservative for a second. Let me take a conservative defense. The but for test is much more consistent with, again, um, what was I say? You mentioned that, and I would argue, and I actually got a chance to talk to Professor Bell, and he actually halfway agreed with me on this. He said Brown versus Board of Education was a failure, even after being the litigator for years, um, because it didn't produce material benefits as far as education for Black kids. I asked him whether or not we could look at Brown versus Board of Education as the point within United States history when racism became bad, when it became the thing to deny upon pain of death, right? That since then it's been hell. I will, I will cry on TV. I will prostrate myself to say I am not racist, right? That is a new norm in the United States that Brown versus the Board of Education brought. However, going to your point in question and comment, it also sets up the but for test because there is such a social penalty for being called or proven to be racist that we allow almost a criminal defense standard, right? That instead of a civil defense standard of preponderance of the evidence, that because being called racist is so bad that we almost have a beyond a reasonable doubt standard, right? Um, and again, if we're using racial realism as far as majorities in control of the legal structure, is it perhaps not surprising that that's so? So that is the conundrum. Narrative is a way to try to inspire empathy. Narrative is a way to try to get people to see outside themselves. On the other hand, and Derek Bell uses narrative, but in some of the critics of narrative say, yeah, but narrative can go the other way too. Narrative is neutral, right? So narrative can also be used to paint Black people or minorities as undeserving, as burdensome, right? Or as lazy or whatever, or as needy and wanting. So narrative does have a lot of power. I would definitely agree with that. But I also would caution that it has power in both directions. We can even describe the fact section of any legal case as narrative, right? Every fact section of a legal case, especially in the appellate circuit, it uses some facts, it doesn't use some facts. It uses adjectives and adverbs very selectively to paint a picture and a tone, right? So the idea that so there's an argument that says all of law is narrative. All of law is actually literature, because it tells
Yeah,
us.
during the reading, it was real weird to me that they like frown. It was like this critique of storytelling and storytelling not being sufficient enough. And I'm like, but you allow testimony as evidence all the time. So I'm confused at how all of a sudden like this standard is not sufficient to establish like legal rules or like legislation when I mean we essentially incarcerate or like
Mhm.
people based on storytelling, like based on like just
Yeah.
testimony from witnesses.
Well, I want to. I think Professor Bridges probably could have done a little bit better job, and I agree with all her points. But in the terms of context, a, a lot of that beef about narrative was not necessarily about judging, but about tenure, right? A lot of that beef about narratives was because we know Derek Bell left Harvard because they would not give any black woman tenure that they had hired. Um, and so this was not just about that particular incident, but there had been kind of a blockade as far as the elite law schools and having critical race theorists and what have you. And narrative, the fact that they wrote in a narrative style was used against them in tenure decisions, that your scholarship doesn't fit the mold. And part of that discussion was, I can't argue with you as a person on the tenure committee, as someone evaluating what you're doing. I have no familiarity with it. I have no idea whether it's good or bad. I have, as far as a writing style, and also as a scholar, or as far as race, I have no idea whether what you're saying actually represents blackness or your people or what have you. I have no, it puts tenure committees in a point where I have no basis of authority. And I think it's really interesting. And I can say that and halfway defend them, or at least not defend them, but at least give them that excuse, because because since then we have broken through, right? That for the most part, that since that writing, since that debate about narrative was in full flower in the late 90s and early 2000s, the narrativists have kind of won, right? So the idea of what scholarship is has broadened. The idea of who even writes scholarship. Now our clinics write scholarship. Now lots of people outside of write scholarship. So in this kind of European Marxism, postmodernism thing, yes, the world has exploded and expanded uh, um, to a point. So I think narrative has achieved a grander place, but at the same time, as it's become somewhat acceptable, I think we use it less. There hasn't been a great narrative writer in law professorship, whether it's race or critical studies, in a while, um, which I think is interesting. I'll give you an author whose books I think has always a very strong legal tint to it, and it has very strong themes of justice and what it means to create a better society. And her name is Octavia Butler, was, she's passed now, but her name was Octavia Butler. And she's written a lot of different. Some people call it sci-fi, some people call it future fiction, some call it Afro surrealism. But she almost every book she's written involves some type of controversy that you could almost consider legal. She wrote a vampire book where there's a trial of vampire families because they broke the rules, and it has race involved. I can't ruin the story, but I'll just say it has something to do with melanin and vampires in the sun. And they have this trial. It's crazy. So I would. It's very interesting that law professors have seemed to have won the fight about whether narrative is acceptable, and then abandoned it. I really don't can't point to too many um, law review articles that are written in a narrative style in 2020. Right? But great points, great points. So again, going back to Derek Bell, though, if we can't, if your point is correct, that but for standard is such an onerous standard, maybe there's other ways to approach it, right? And have we even followed his prescription without saying it? Some people will argue that chief diversity officers in major corporations, if you're a pessimist, if you're a critic of them, your argument is that's just Derek Bell's Racial Preference Licensing Act, right? That companies are insulating themselves from lawsuits, not by a license, but by spending the same amount they would spend for a license to have chief diversity officers and have Black History Month programs and other types of charitable giving so that they insulate themselves from lawsuits, even though their hiring practices haven't changed, right? Um, a second thing that we do that perhaps makes the Racial Preference Licensing Act seem not so weird is that we've already kind of done it. That in the 19th century, instead of giving full effect to the 13th, 14th, and 15th Amendment, instead of giving full effect to the Civil Rights Act, we said, you know what, instead, here's a whole bunch of historically Black colleges and universities, right? Then instead of having you sue to gain access to general society, we will instead use funds to build up your own social capital. And so I just want to leave this discussion with expanding it to other preferences, right? Because you don't have to be Afro-pessimistic. You can be pessimistic about how the law treats gender, how the law treats class, how the law treats sexual orientation or ethnicity or what have you. You could rationally believe that no matter how much advocacy is thrown at the government and voters, that there's a limit to what the law is going to do for your group, and that perhaps there is some other types of programs that can bring about a better sense of justice for your group. So should we consider license preferences for race, for gender, for religion, right? Especially if we think about so-called reverse racism, right? Or reverse discrimination, right? Should we be broader? Should we have a broader based program to accommodate the First Amendment, right? The idea that I don't have to like Black people. I can say whatever I want so long as I don't actualize it, or the First Amendment protection on religion, right? Both of those constitutional provisions have been used to shield racist, what some would call hate speech or racist speech, right? And the question becomes, which is not necessarily which is more morally superior. Perhaps the question is which is more materially effective. Those questions may point in two different directions. Okay, so it's what time, and we're still on class 3. We're still reviewing. All right, so let's talk about, so any questions? I'm sorry, any questions, comments, concerns? Derek Bell, the Byron Allen case. Byron Allen case was actually remanded because there was still a remaining question about racism during contract formation. It had still allowed the case to continue and give Byron Allen a slight chance of winning. And I believe within the last month or so, the case settled. So that question will not be entertained and go back up to the Supreme Court. Any more questions? Any comments, concerns? All right. So class 4 this week. So I happen to work with a very, 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 very intelligent professor. Used to be the dean of Duke I'm sorry, the president of Duke University and all types of other stuff. Really takes education and what it means to be a scholar very seriously. I'm very fortunate to have met his acquaintance and had his mentorship. And one of the things he told me, and I'm not that good at, or I always strive to be better at it. But he always talked about what it means to have argument, what it means to win argument, what are we doing when we're legally arguing. He suggested, and I think it's a very good suggestion, to restate your opponent's arguments in a way they wish they would have done it, then smash it to bits and pieces, right? That unfortunately I feel like I'm not one that tries to do this generation versus that generation, because my generation created this generation. So if there's anything wrong with this generation, it's because that we made it this way. So I don't like to get into all that. However, I do have to say that whoever's responsible, we tend to belittle other people's arguments and then attack them, right? And that always leaves them, I don't think that's very productive, right? That's how we fight. And not only do we just fight that way, we're not really, there's hardly a way to come together and see points of agreement when I'm not really arguing against what you're saying and you're not really arguing against what I'm saying. I'm arguing against a caricature of what you're saying. You're arguing against a straw man of what I'm saying, right? And then that, to me, that just leaves the confusion and non-productivity. I mean, why even engage in the argument at all, right? So that's great for rhetoric. But in the law, if we're trying to get to truth, if we're trying to get to justice, if we're trying to quote unquote win through logical means, then I think the most impressive way to teach through argument, again, is, as Professor Fish stated, restate your opponent's argument in a way they wish they would have done it, right? So that's what we're going right here, is we're going to not just bash not just promote critical race theory, but deal with the critiques of critical race theory and hopefully do it in a way that the critics would agree with, because I don't think it's insurmountable. I don't think any of them have a critique that can't be countered, volleyed, and we continue on and move on, right? I think that is a flaw of some critical race theory of decades past, is to run away from certain critiques instead of taking it head on. So first of all, let's even go back to this idea of narrative. One of the reasons why we use narrative, and as Mr. Schmeling also pointed out, that there's an argument that critical race theory emanates from a theoretical perspective called postmodernism. Postmodernism can also be linked to what's also called existentialism, right? This idea that there is not, and we can even make it a little conservative by linking it to what's so-called pragmatism, philosophical pragmatism. This idea that there is not necessarily an objective truth, right? So we're going to deal with a little philosophy here, a little 15 to 20 minutes of just of beating our brain up. Does 1 + 1 always equal 2? Right? That's, we all, 1 + 1, when somebody says, oh, just do the math, right? Or 1 + 1 = 2, right? It's just that simple. Is it really that simple? Can we even pick with the idea that 1 + 1 = 2? And of course, I'm going to argue that yes, we can, right? So if we're going to do this existential or postmodernist, anti-essentialist critique, let's start with the idea that 1 + 1 does not always equal 2. What if you have anybody into exotic fish? Anybody? I have lots of friends who've had these fish tanks with these deadly fish, and it's probably not cool that they set them against each other, but they do that type of stuff. And so we know that if you put one Oscar in a fish tank with one snakehead, you do not have two fish. You only have one fish. The snake is going to win. The snakehead is going to win. The Oscar is not going to be anymore. All right, what if you have two rabbits? Well, two rabbits tend to make 3, 4, 5, 6, 7, 8, 9, 10 rabbits. Right? Okay, but you're saying they need to be the same rabbit, right? Well, how about then two snowflakes? Because I've always heard there's no snowflake is the same as any other snowflake, no matter how many quadrillions of snowflakes there have been or will ever be. So which is the snowflake that represents the perfect form, and then the others are an nth degree off of it? So aren't you always, if you have 1 plus 1, you have one snowflake and another snowflake, don't you have 1.99999999999 snowflakes? Or 2.000000001? Can you ever get to 1? Aren't you always an nth degree, at least theoretically, in mathematics? Has anyone ever gotten to a 1? Have you ever even seen a 1? Have you ever been outside and saw a 1 running across the street against traffic about to get hit? Hey, 1, stop. Right? It's point 0.3 to infinity. All right, so you can go on, right? So all of this is to say that if we, as lawyers, and we know this as lawyers, right? If I'm going to defend, I can defend any defendant because I don't know whether they actually did it. Right? I don't know. Right? No matter how much evidence you put on one side, I don't necessarily know. Now, what's a jury's job? Even as a jury, I may not know. I can't know for a fact whether they did it or not. I can, however, rescue all of this through what? Consistency, coherency, right? Utility, scientific inquiry, the idea that what we know that in most instances, 1 plus 1 equaling 2 will be a useful estimation for what we're trying to accomplish right here. Even if I can pick at it in theory, right? So I say all of that to argue that narrative, and just what I've done here, right, is a way to pick at the idea that the law is just like mathematics, that the law is just a set of objective and neutral rules that command something predetermined without any human biases involved. That if math can't do it, then the law can't do it, right? Um, So again, Afro-Lanica Awake, Patricia Williams, probably the leading scholar dealing with defending narrative his name is Charles Lawrence. He's at the University of Hawaii. I believe he's married to Mary Matsuda, who is also one of the foundation scholars in critical race theory. And his specialty is, again, yes, the description of law as literature and the importance of um, uh, narrative as a means for uh, creating empathy. And also, again, he is very consistent with critical legal studies in the larger event, right? Critical race theory, as I remind you, emanated from what was called critical legal studies before it. The idea that power controlled the law more than abstract rules. Critical race theorists identify that power as white supremacy or white male supremacy or white male hetero supremacy or what have you. They become very specific about it. But prior to that, critical legal studies it was first in arguing that the law emanated from power bases first, right? And so Charles Lawrence accepts that original description and says, well, if that's the case, If power is defining what's going on, then how do you affect power? How can you can't do it with the rules? You have to affect power with the narrative by getting to hearts and minds, right? Um, However, one of the criticisms of narrative is, are there voices of color, right? The idea that um, Black people speak in a different voice or have a different experience. What is the Black experience? Number one. And then number two, even if you think there is a Black experience, which is highly contestable, right? Even if you think there is a common Black experience or an essential Black experience, is the person writing qualified or authorized to give it to you, right? I was reading a book, the book Afro Pessimism, that I've written. Again, I follow Derek Bell, and Afro Pessimism says they follow Derek Bell, but then I have a beef with Afro Pessimism. So when I'm reading Frank Wilderson's book, his experiences are different than mine. Frank Wilderson, who wrote this book, Afro Pessimism, went to private schools all his life, and the rejection he felt in from elementary school, public high school, college, in these private schools where he was one of very few Black people there, had a profound effect on him. Charles Lawrence also says the same thing. I'm from West Philadelphia. I went to public schools all my life. So I was always in a setting where Black folks were in the majority. Most of my teachers were Black or what have you. So some of the things that happened to them that shaped the way they experience life didn't happen to me. And I am almost as foreign to it as perhaps some of you are, right? So the question becomes, does Frank Wilderson or Patricia Williams or Derek Bell or Andre Smith, are any of us authorized to give the Black experience, even if one exists? And how is someone outside of the race or the construct to know the difference, to know who is authentic and who is not, right? So that is one of the arguments against narrative, that some narratives may be atypical, that that's not the typical Black experience, even though the author suggests that it is. Secondly, even if it is, if let's say it is the authentic Black experience, doesn't that then essentialize Blackness? And now whoever doesn't conform with this experience is now not Black? And isn't that its own injustice, right? Um, Classist, right? Won't, even within the Black community, won't those Black folks with means, with resources and wealth, won't their stories be told more accurately than those without wealth? And isn't that exploitable, right? The that if the reason I'm writing this paper or this scholarship is to get tenure. So my narrative still has to satisfy those who have something that I need, that tenure vote, right? And therefore unconsciously gets massaged to please, right? Another criticism of narrative is, well, it's frustrating to those who disagree, because how do I disagree with your feelings? How, if I am a critic of critical race theory, if I'm on the other side of the argument, how do I read your narrative and then logically or morally or whatever just say, I'm not feeling what you're feeling, right? I deny your feelings. I deny the importance of what you are trying to get across to me, right? And also, if I do, am I, how do I distinguish critiquing the idea versus critiquing the person, right? So all of these are criticisms against narrative, that have been levied against narrative. But again, we go back to the last page, and I don't think any of them defeat the idea that law, all of law is a particular narrative, right? That all of law comes from a particular perspective. Just because some perspectives have been entrenched within the law doesn't make it any more natural and others outsider. Okay. Richard Posner, and I've mentioned his name before, is probably the most virulent and aggressive critic, or was. He recently passed, maybe 4 years ago. He's one of the most virulent critics of critical race theory, and particularly narrative. He was a very powerful writer because not only was he is a, and let me make no mistake about it, I've read his work. He is a tremendous thinker. It is not a simple task to deconstruct Richard Posner. If you're a competitive person and you believe in reading the other side's playbook, Richard Posner is definitely someone that you want to address. Mackenzie, Sarah, you have a comment?
I was just gonna ask. Once I read his like very, I don't know, it was very powerful and very angry and very
Yeah.
aggressive. So I like kind of spiraled trying to do a little more research on him. And outside of some of the cursory like things that you sort of just mentioned, very great writer, well respected in that regard. He wrote his own opinions, appointed by Reagan, which to me says enough. But I just didn't know if he had been personally victimized in some way by this to have this type of response, because I couldn't really find anything.
Uh, I do not. I don't know any. I don't know if anyone has pointed to anything personal in his early life that led him to be so uh, aggressive in his criticism of critical race theory. I mean, there are a lot of people that critique critical race theory, but we're going to talk about it again. This idea of lunatics. I mean, that you have not heard or seen such types of criticism hardly before or since. Um, and it wasn't reserved just for critical race theory. It was for Afrocentricity and Black studies and whatnot. He's also critical. And the interesting thing is, and not just that he's a critic that teaches at University of Chicago Law School at a top 10 university. This is the chief judge of the Seventh Circuit, right? So where most judges refrain from writing anything at all controversial so as to make them seem impartial or partial on the bench, I mean, he goes full bore. I mean, it's almost impressive. Um, but it is impressive in the sense that when I read his work, you get a sense of honesty out of it, where you get a sense that at least I'm reading someone who will not hide the ball, right? Who will defend economics and races and will outwardly say that some forms of racial discrimination are in fact efficient and therefore the law should not get rid of them. To have someone that actually is that honest is actually a benefit to me, right? So um, uh, he is one of the chief proponents of law and economics, right? And he was his partner in crime was Gary Becker. So Gary Becker's work also speaks to Judge Posner's reluctance about race. They had the Becker Posner blog for years until he passed. That was one of the early legal blogs that were even out there that have lawyers, law school professors actually communicating with the public. Uh, and Gary Becker wrote the book Economics of Race and Discrimination, where he wrote that legal interventions into race relations is uh, inefficient for the country, that it makes the country less wealthy, and and that the market will eliminate racism anyway, eventually, right? So that highlights his intellectual disagreement with legal interventions into race, but it doesn't, as you point out, but it comes nowhere close to explaining the vitriol that he has about it. Because Gary Becker book, his book that's based on, I've read that book, and Gary Becker writes it as if he's a friend, right? He writes it as if, yeah, I know you want civil rights legislation. I know it sounds good, but it's distracting, and the market's going to get rid of it anyway. He's wrong, but at least he tries to offer it as a way out of racism. Whereas Richard Posner, this concept of lunatics, he's defending, let's look at it this way, he's defending an objective standard. He's defending objective standards against critical theory. But he calls, let's say, through, if you believe those standards are objective, if you believe they are objective standards that relate to quality, then what he is saying, this is inescapable to me. He is saying that the elite, the smartest Black people on the planet, the ones that have navigated Harvard and Yale University, the ones that have excelled and been on the law review, the ones that have thought about these things deeply and whatnot, are lunatics. And if the best and brightest are lunatics, then how do you feel about the rest of us? So it is very problematic for me. However, again, the honesty of it and the brashness of it reveals what some others may be thinking, even if they don't say it. Right? We can, if you believe. So there's a myth of what I call the myth of Black inferiority. Right? If all humans, right, our brains function very, very similarly, regardless of our experiences, and it is those experiences that each of us have that creates differences and all that other stuff, nature versus nurture and all that good stuff. But there are people, including Black people, that believe that Africans, prior to coming to the United States, were from backward civilizations, and that slavery perpetuated that lack of intelligence, and that Black people, since the end of slavery, are catching up, right? That are catching up to civilized society. And for people like Judge Posner, who seems to me believes that, because again, he attacked Afrocentricity. Afrocentrics are historians that argue that Africa was just as advanced as any place else, that the only difference was technology, right? But if you do not believe that, and you believe that the West brought civilization to the rest of the world, then you can defend Richard Posner by saying, well, Black people should be treated equally when they become equal, which will be a process that we are waiting on, right? So that's also a way, when we talk about narratives, history is narrative, right? Every history book we ever read represents a narrative from a certain perspective, right? And so this history of did are African Americans, did your history start at 1619? Does your history start in West Africa? Can you claim all of Africa? Was Africa the cradle of civilization? Was it backwards? All of those things build all the way up to our attitudes about race today, that then come out in the words of, let's say, a Judge Posner on the one hand, or unspoken from others who aren't as strident and brash as Judge Posner. Let me just say, close out with Judge Posner, that he is also the author of probably one of the most pernicious cases that's on the books right now, Marion versus Crawford. This was, I believe, 2009 or 2010, where he held in the Seventh Circuit that the incidental costs attached to rules and regulation of voting can never be a poll tax, right? So if I require you to pay $10 for a voter ID, that had been held a poll tax. Can't do that. But if I require you to get a voter ID and I limit the forms of identification, if I close down all the places that offer this voter ID and put them in one part of the state that has no access to public transportation, if I close down polling places, if I do all of the things that make voting more expensive, it can never be considered a poll tax against the US Constitution, right? He apologizes for this case after he retires, and it becomes evident that the Republican Party creates an entire strategy of voter suppression around it. This is our basically now. Everything he said is not wrong, right? Everything he said is not wrong, or at least not. His every argument he has is not lunacy, right? There is some narrative does have its limitations, and there is law and economics pushes empiricism, right? Economics deals with lots of statistics and numbers, and the idea that even if the law can't be neutral, even if text can't and intent can't be neutral, at least if we're going to consider public policy, at least if we're going to consider the purpose of the law, the consequences that the law promotes or avoids, let's at least do it scientifically. Let's at least do it empirically. And that's the draw or the sell of law and economics. Now, law and economics is, of course, not the only field in the social science that uses statistics heavily. It's not the only field that deals with data, large amounts of data scientifically. And so Osagie Obasogie is a critical theorist who I absolutely agree with, who argues that critical race theorists need not run from empiricism. Yes, narrative is great. Yes, narrative can cause people to stop and think, can change hearts and minds. And yet we still deal with the law in which we want judges to make decisions that are defended on the basis of impartiality, right? We still are, most people, 90% of people are not willing to just give up on the law and say that all judges can just do whatever they feel like doing because the rules of interpretation and opinion writing is just a bunch of nonsense. Most people still read those judicial opinions for guidance as to what the law is. Most people believe that there is a such thing as the rule of law, that judges and other legal actors are constrained by precedent, are constrained by the text, are constrained by the intentions and expectations of the legislature, of Congress, and what have you. So if the people aren't willing to give up on it, then critical race theorists, Obasogie argues, have to embrace at least this idea of so-called scientific realism, right? This idea of if I want to say something is racist, if I want to say something causes pollution, or if I want to say something, affects us, these people negatively, that I have lots of research data and statistics to back up my story, and that the narrative gets you interested, but the numbers get you to act or to believe or exceed a certain standard of proof. Now, going back to Ms. Ramirez about that but-for test, we also know that statistics alone under Washington v. Davis are not sufficient by themselves to prove racist intent. However, even though it's not sufficient, it is necessary, right? For those, again, there's a wonderful paper out right now, Neil Buchanan and Michael Dorff, and they ask, again, if the critique of originalism and textualism and law and economics is that they're really empty, that they can be manipulated to come up to any decision that you want to, that they're not objective, that they're not neutral, then why don't liberals adopt it and take it over and co-opt it? So as a matter of fact, by the end of this course, I will show you how I think liberals and progressives, in fact, can co-opt originalism, textualism, and law economics to get the consideration of group subordination injected into those discussions. I call it racially asymmetric market imperfections, and that's all I'm going to say about it right now. We'll deal with that stuff weeks in the future. The criticisms of narrative and storytelling are there's more. Is not the goal of the law to surpass and suppress empathy? Isn't the goal of law to privilege logic over emotion, right? What of objective and neutrality? Aren't judges and administrators in the democracy supposed to follow orders? Can you call it a democracy if the judges have more power than the legislature? If the legislature can say something, write it down after a vicious fight, committee reports, hearings, etc., and then a judge look at that law and say, I don't care what it says, and I'm just going to do what I feel like doing. Right? Is that converting your democracy into a theocracy? Right? So again, this idea that democracy demands the consideration of text, that democracy demands the consideration of intent and purpose is a very strong one. It's a very strong one that most legal theorists accept. Judge Posner actually doesn't. It's kind of funny. He's like, nah, what am I, a potted plant? The reason I'm here is because I'm smarter than y'all. It's really interesting stuff. Okay, but and should critical race theorists, do critical race theorists have an unrealistic view of the honesty and goodness of people? Right? Is everybody interested in justice? Should such that every decision maker be allowed to make decisions on their own preferences? We just had a president that I don't trust that president's sense of justice. And contrary to a lot of discussion, he's not the first of his kind, right? So as far as Andrew Jackson, Millard Fillmore, Woodrow Wilson, Andrew Johnson, do you want them and their administrators having not constrained by text, not constrained by rules and norms and the aspiration to be objective and the aspiration to be neutral? And then I offer, again, one of my own personal critiques, and this is based off of Afro-Atlantic Awake that we read a couple weeks ago. Would there be a difference in tone? Would there be less emphasis on narrative and more on the formal structures if crits were not set in opposition already to the current social order and the current status quo? What if crits, the critical race theorists like myself, didn't represent the faces at the bottom of the well? Would we have more empathy for shareholders? Would we have more empathy for the maximization of wealth of the country? Right? Would there be a difference if the charge were to construct a legal system instead of critiquing a legal system? Okay, so that's one of my own personal critiques of my colleagues, gentle nudges, right? So to go over, I guess, a listing of a lot of the critiques of critical race theory by ideological camps, because we just got started. There's so many criticisms of critical race theory, but again, I don't find any of them damning. I don't find any of them to obliterate it. Before we move on, is any questions, any concerns, any comments, any? Okay, so from a formalistic perspective, and formalistic, we can also try to perhaps equate that with conservative. Again, I've sort of referenced these critiques. Number one, again, from the formalist, CRT is somewhat illegitimate because judges are neutral and objective, and they do not consider any public policy, right? Again, this was the stance of Justice Scalia. This is sort of the stance of Justice Gorsuch and also Justice Thomas. The idea that, and secondly, the corollary to that is Even if it is not possible to accomplish, judges should aspire to be neutral and objective, and therefore judges in a democracy should not consider any public policy. That is the strongest argument, or the one formalists use to bully people in judicial appointment hearings, right? The judge as referee, the judge as strictly umpire to a sporting event that takes neither side, that just allows people to beat the snot out of each other so long as it's within the rules. Right? That takes no interest in the outcome of who wins or who loses, whether it's a blowout or a close game. Now, interesting for my sports fans, we know some judges, some referees and umpires, they swallow the whistle in the fourth quarter, or they have certain biases or whatever. So we're just going to leave that alone. More formalist critiques. The law should only recognize individual rights because race does not exist. Right? The law, as intended by the founders, only recognizes individual rights even if race exists. Or the law should only recognize individual rights as a means of obliterating the concept of race. In other words, Justice Roberts has stated the way to end discrimination on race is to stop discriminating on the basis of race. Well, again, it would take me too long to deconstruct each one of these arguments. So we'll keep moving. Class crit. If anybody wants me to debunk any of these arguments, if you don't, if the opposite doesn't seem natural to you, I can definitely do it. But for time's sake, we're going to have to move pretty quickly. So from a class crit, a progressive hesitancy, right, to recognize race, right? So as a class crit, critical legal studies, even though critical race theory emanates from critical legal studies, there's at some point became something of a division to some. And so some critical legal studies scholars do not appreciate critical race theory and back and forth. Now, I think there's more partnerships than not, but there is that cadre. And why? Because some class crits argue that yes, the legal system is systemically biased. Let me say that again. The legal system is systemically biased, but racial legal issues are indistinguishable from class legal issues. Or that the legal system is rigged, but racial legal issues are resolvable only by dealing with class legal issues. Right? How student loan forgiveness, for one aspect, right? Student loan forgiveness is a way to deal with class inequality, is a way to also spur the economy. And then third, because Black people are disproportionately without wealth, they are disproportionately subject to student loans to fund education, and therefore the cancellation thereof would be a disproportionate benefit to Black borrowers, whereas most of the times the law is disproportionately harmful, right? So this argument that to address race issues, we should address class issues, right? And that the legal system is rigged, but racial legal issues are a distraction from class legal issues. This is the argument that race is not only just made up, but race is used by the powers that be to distract from income and wealth inequality. It is the argument that there are so-called neoconservative forces that hold the wealth at the top, and we can call this so-called Straussian neoconservative. There's a philosopher called Leo Strauss in the 1900s. The book on the Bible of Neoconservatism was written by Irving Kristol in the 80s, and it argues that the ideal society is one that is stable, and the ideal society has a stable aristocracy, very small, that is supported by even the smaller number of philosophers, and that they govern over the vulgar, right? The masses who are basically ignorant and need to be set in perpetual war against others, foreign or domestic, real or perceived. And that is how, and that the way to nobility for the vulgar is through military service, right? And so the other that the vulgar are set upon, again, foreign or domestic, right? The idea of setting poor whites against blacks, or poor whites against Muslims, or poor whites against whomever, to keep them focused on others instead of focused on wealth inequality, right? So that is very much a very akin to what Posner would call a Marxist critique, right? There's more critiques of critical race theory. How about from the realist camp, from the camp that does in fact think the law should consider consequences in public policy, so long as in most cases the legislature intended for them to do so. For them, the law can recognize public policy issues, including racial issues, but with no more emphasis than myriad other issues. And so that is a way that race gets considered, but then lost in the mix, right? A way to consider it, but then dilute it, right? Because if it's just one factor, and maybe that's appropriate, but if it's one factor amongst 75 others, then how does it ever become, how do we ever make changes, or does it ever become impactful? So for example, Deborah Archer, who was at NYU, she has just been named the executive director of the ACLU. Very proud of Professor Archer. And I had just reviewed one of her papers that she wrote about racism in transportation, in the Federal Highway Act and whatnot. And she talks about the racial impact studies that the law already requires governments to do when they want to put a road through people's neighborhoods, right? And these roads separate the neighborhood from downtown business district and a bunch of jobs. The road brings in pollution, noise pollution, gas and methane pollution into those neighborhoods. And that they always seem to go through what they call it NIMBYs, not in my backyard, right? So if you have the wealth to keep that stuff out of your neighborhood, you do, but those who don't have to suffer. And who has the least wealth to fight against these type of externalities? Are people of color, especially poor people of color. Now, the laws have been amended to require racial impact studies, and these racial impact studies are done, and yet the roads still go through the black neighborhoods, right? Because it's only they're only one factor within many others. And again, for those that have taken administrative law, the arbitrary and capricious standard requires that you get a right to be heard, but not necessarily a duty for the court or the administrative agency to listen. So long as they have recognized what you said, they can go on and make the decision they had always intended, so long as they gave you the right to be heard, right? More critiques. The reluctant realist says yes, there could be intervention, government or legal intervention into racial issues, but only if and when black people carry the burden of proving the existence of racism. So here we're again talking about anti-narrative. Is narrative enough to prove that racism exists? Is it enough to just describe what this particular mother is going through, or this particular voter is going through, to say that racism is existent? Or the reluctant realist may say yes, but only if and when black people show that race is the only factor causing harm, right? A lot of people, you see this on Facebook all the time, you see people pointing out this was a racist circumstance, and someone will say, well, do we know all the facts? How do we know it wasn't because this? How do we know it wasn't because of the neighborhood they lived in? Or how do we know it wasn't because, right? So this idea of clear and convincing evidence being stretched all the way to beyond a reasonable doubt, where there's no intervening factors. Or the reluctant realist may say, yes, the law should intervene, but only if and when Black people prove the existence of racism by scientific means. And so again, is this uh, Obasogi, is he capitulating to this, right? Is this the appropriate standard? Even if we can carry that burden, is it appropriate to begin with? And again, I put when Black people prove the existence intentionally, right? Because the question becomes, um, can we expect, is it rational, allowable to expect others to do it? Um, we can go into a lot about that. The reluctant realist, oh, we got plenty. We're going on further. The reluctant realist says yes, but only when Black people construct and teach white people exactly how to do so perfectly. We've seen that in taxation, where critical race scholarship is criticized because it doesn't come out with the perfect solution, right? Yes, but only if Black people show that the legal resolution solves the problem perfectly and permanently. Or yes, but only when Black people must prove that they have exhausted all internal and social remedies first. What about Black on Black crime? You can get a lot of these arguments in a very profound book by the sociologist Eduardo Bonilla Silva, in his book that he wrote, and I think around 2008, called Racism Without Racists, right? What are the reasons and excuses that we offer all the time to where racism still exists, even though nobody's racist, right? Law and economics also is part of the realist camp. And again, they don't necessarily say they're absolutely against intervention into racial circumstances, but they disfavor it. So yes, the government should intervene in race, but only when Black people prove intervention will not hurt the economy by 1 penny. That is what is meant by the argument that certain rules are inefficient, right? That they constrain social choices and therefore bring down the wealth of the country, right? That private ordering rather than government intervention appropriately sets the supply and demand curve, and any other point of supply and demand that's artificially produced by rules or civil rights laws creates, and I wish I could do it mathematically for you, but creates what's so-called dead weight loss, right? That instead of a $1 trillion economy, you have a $900 billion economy. Now, of course, the response to that is saying, wow, we just not worth it, right? That, okay, solving racism just isn't worth even a penny, right? That any type of description of inefficiency scuttles civil rights laws. Or yes, but only when it is at no financial cost to the taxpayer or to the market, right? So Comcast, the Byron Allen case, we can, you can clearly see a concern in the Byron Allen case for shareholders and companies that would have to defend a lot more lawsuits, right? That would accuse them of racism, right? Playing the race card, right? Not just being personally offensive, but increasing the litigation costs of large corporations, right? Yes, and yes, the U.S. Chamber of Commerce was in fact in support of Comcast in the Comcast versus NAAOM case. And yes, but only when it also helps corporate America. And so this is a hint towards interest convergence, right? That there doesn't seem to be as much of a reluctance to have civil rights intervention into the labor market, because broadening the labor market actually helps corporate America. It helps them bring in greater amount of talent. And it also suppresses wages because you have a greater labor supply with the same amount of demand, right? Right now, even right now, there's defunding the police and all the things Black Lives Matter have argued for don't seem to be happening. And yet there is a piece of civil rights legislation that is advancing all throughout the country called the Crown Act, right? The Crown Act is a law that prevents employers from discriminating against Black people and people of color because of their hairstyles, right? And because it's focused on, again, broader employment participation, it is being enacted in states across the country almost one every 2 months. Right? But it is one that would seemingly help corporate America. Critiques of CRT by, let's say, Bell's interest convergence theory. So these are the unspoken rules, right? Yes, it can interfere, but only when a racist perpetrator and their actions are identifiable. It seems that the Supreme Court will, in fact, it's not like the Supreme Court has never ruled in favor of Black people. That is a lie, right? They have done so. They have ruled in favor of gender. They have ruled in favor of the recognition of sexual orientation. But the argument may be that they only do so when the perpetrator is just so outlandish, right? And that there is a perpetrator and that their actions are identifiable, that they won't have anything to do with structural racism, but individual white supremacists or individual misogynists or individual, right, can be sanctioned because they're more or less embarrassing to the rest of the country, right? Or yes, but only when it serves the goal of assimilation or post-racialism, right? Those are those folks that say, why is there an HBCU? Why is there a Black student union? Why are there classes in critical race theory? Anyway, yes, but only when it makes America look like the land of opportunity to the rest of the world. Yes, but only if the law also recognizes reverse racism, right? So those aren't spoken. You won't find many of these in scholarship, and yet some people believe that that's what the courts and folks are actually doing. How about some Black critiques of critical race theory? Right? Black folks are not monolithic. Not every Black person believes in critical race theory. Over 10% of Black people voted for Donald Trump and Republicans or what have you. Right? So what are the Black conservative critiques? What are the Black nationalist critiques of critical race theory? Number one, the law should not intervene into race relations because it will upset white people. Right? That it is better to just get along. Right? Booker T. Washington is unfairly, is the Black leader that I believe is unfairly, but regardless, is typically linked to this idea of assimilation and pulling up by the bootstraps, pulling yourselves up by your bootstraps instead of seeking help or intervention. Because even if sincere, it will perpetuate the myth of Black inferiority. This is Clarence Thomas. Right? The argument that if Black people always need the government to save us, then we will always look for the government to save us and you will not take the steps to create your own equality. Because if sincere, it will perpetuate the myth of Black inferiority. So you don't even have to think that Black people are inferior, but the fact that you're always, if an alien or came from another world and looked at our laws and saw that there's all these interventions for Black people, that they would think naturally, well, these folks need help inherently and not necessarily contingently. A Black nationalist critique might be a little different than a Black conservative critique and may reject CRT because even if sincere, government intervention will only be done badly, right? That why would you trust a system that you say is systemically racist? You're asking a systemically racist system to unracist itself. Or more subtly, Franklin Delano Roosevelt. Nobody believes that Franklin Delano Roosevelt was a racist. I've never heard that critique of FDR. The New Deal was a very impressive program very class progressive program. However, most of the New Deal programs excluded Black people. Social Security did not include agricultural or domestic workers explicitly. And over 85% of Black people at the time of that enactment worked in agricultural and domestic capacities. The protections for union organizing had no protections for Black folks that were systematically excluded. The National Realtors Association, et cetera, et cetera, et cetera, et cetera, et cetera. So the argument becomes that even when there are class projects, or even when there are attempts to do civil rights, that they're just done in a way that's allows folks to say they did something, but not actually affect race relations in a positive way. In sports, we call it fake hustle, right? Somebody that looks like they're playing really hard defense, but they're just moving around a lot and gives you an impression that they're doing so. Or because intervention will only be a ruse toward the illusion of inclusion, Afro-pessimism as distinct from racial realism. Yeah, that's kind of a similar critique. How about an intersectional critique? We can keep going. There's so many. Intersectional critique. How about a critique from groups within Blackness? So intersectionality is a term that's popularized by Kimberly Crenshaw. We'll talk about it more specifically next week, about that Black women have often been caught in between, where the law may recognize women's rights, it may be respect Black men's rights, but then Black women are left in between. And there's a case called the General Motors case where she makes that point. We'll talk about it in more detail next week, but what happened was there were plenty of Black men that worked the factory line. There were plenty of white women that worked in the administrative offices, but there were no Black women anywhere. And they couldn't win their lawsuit because they couldn't sue on race discrimination because there were plenty of Black people, because Black men worked the line. They couldn't sue for gender discrimination because there were plenty of women that worked for General Motors. They were all white women, right? So the fact that there were no Black women in general working for General Motors could not be resolved by race discrimination or gender discrimination laws, right? And so that started her or was her initial foray into describing intersectionality, right? That even within the Black community, there are subsets of Black folks that get subordinated, and perhaps even by other Black folks. So hesitant because intervention from white male hetero hegemony will perpetuate Black male hetero hegemony, or hesitant because intervention will perpetuate Black capital classicism, propagating the Black bourgeoisie at the expense of the Black working class, right? And again, this emanates from this idea of critical legal studies, that if power is in control, if wealth is in control, then asking the law to respond is just asking for those power bases to do what they normally do, right? We'll talk next week about more big tent critical critiques. This would have led us today into our discussion of lat crit theory, right? And again, I predicted that we would get here. We've only got like 5 minutes left, and we're not going to be able to really deal with lat crit. So we're going to have to deal with it much more fundamentally next week. But big tent critiques, CRT critiques, hesitant about government intervention because it is less effective than social cohesion and advancement, right? So this is the argument about Asians and Jews as the model minorities, right? They didn't need or rely so heavily on legislation, or that hesitant because Asians, Latinidad, and others should not suffer from racial remedies. And this is really interesting because there's an affirmative action case brought by to represent Asian students, right, that believe that they are discriminated against because of affirmative action programs that accept Blacks with lower scores, however, refuse to admit Asians with higher scores than whites. So what is the concept of equality that prevents Blacks from, that allows Blacks to be accepted into these programs with lower scores, and yet Asians to be not discriminated against, even though they have higher scores. Or in reparations, if we were to have reparations and the government were to pay, doesn't that mean that taxpayers of Asian or Arab or South American descent are contributing to a harm that they may or may not have any part of? Or hesitant because a black-white paradigm ignores racism against Asians and Latins? Or that a big tent critique would be that no intervention should happen unless all other groups also receive the same interventions. Now that one seems to be in effect. That one seems in most instances that when we do write civil rights legislation, we do write them broadly. However, not broad enough for some people. And also that perhaps intervention is obsolete because the majority minority demographics in this country is inevitable and near, right? And therefore the balkanization is not necessary. All right. So those are all the critiques of critical race theory that I can think of or have come across and what have you. So any comments, questions, concerns, any of them not clear, any of them particularly striking? All right, all right, all right. Well, in the last 5 minutes, again, we'll just preview what we're going to do next week. So next week, we are going to deal very heavily with lat crit, right? Again, the chronology of critical race theory to me is so resembles hip hop in such a profound way to me. It's almost in the 1990s, lat crit became a thing almost around the same time as reggaeton and other ways that hip hop crossed over into other genres and other hip hop artists like Big Pun, Fat Joe, Master Ace. I'm sure you guys don't know these folks I'm talking about. But that, and even that doesn't negate the fact that Latin writers were instrumental from the very beginnings of critical race theory and the very beginnings of hip hop. That even though it branched out into something new in the 90s, Richard Delgado was down from the beginning. Margaret Montoya was down from the beginning. So critical race theory had never been exclusively about simply the black-white paradigm, because its earliest scholars included several critical race theorists, which also resembles hip hop. Even though reggaeton and all that came in the 90s, in the 80s, the graffiti artists, the break dancers, the New York City breakers, Boogaloo Shrimp, all them. I mean, it was a heavy Hispanic contingent in the early days of hip hop as well. And so, long hot summer, that is fire, right? So some of the issues that we're going to talk about when it comes to lat crit, contemporary legal issues, violence and discrimination, all right, hate crimes, again, disparate treatment legislatively or administratively, immigration issues, globalization issues, which I think is really, really interesting when we deal with United States treatment of not just Puerto Rico, but also islands like the Mariana Islands or Guam or what have you, right? This idea of American, but not quite American. Also issues, of course, with policing, issues with, again, positive rights, right? The instead of the government not doing things for me, right? That's most of the Bill of Rights, that the government can't deprive me of my life and law, liberty and property without due process of law. It can't write laws about religion, right? Negative rights. But what about positive rights? Is there a positive right to education, positive right to health, housing, and welfare? And are those positive rights equally or equitably distributed? Or how about inclusion? I've talked about the illusion of inclusion. What about real inclusion for those that want it? In terms of such as language recognition and things of that nature, cultural recognition, right? And of course, I'm sure some of you may think of issues that I may have missed, but those are some of the many of the issues that we're going to deal with in class 5 as far as lat crit, and then also into intersectionality, then with Kimberly Crenshaw. And of course, intersectionality goes in lots of different ways. Black women on the one hand, but Angela Davis, Professor Davis at American, is famous for her book, Policing the Black Male, right? Saying that there's a particular construct there. Or a good friend of mine, Vinnie Harpalani, who deals with blacks of Asian descent, right? Especially those from like southern Southeast Asia. All right. So I've taken up enough of your time. I will see you next week. I will look forward. Please contact me this week and up till next Wednesday about your preference for final exam versus a writing product. And then if you are unclear about what your writing product or project will be, definitely let's set up a time to talk about it. Anybody, I'm sticking around if there's any questions or concerns or comments.
I was just going to say, Professor, people definitely, I mean, I think I know Big Pun, Fat Joe, like that's like, I mean, we know who they are.
That's what's up. That's what's up. All right, you guys, I appreciate you and I will see you all next week.
Thank you.
The sound and picture and everything quality was so much better today. So wherever you're standing is absolutely perfect.
Thank you. I appreciate that. I needed to know that.
Yeah, no, and I just only wanted to stay behind and say, so my undergraduate, I focused on international relations and did a lot of work in internet, like IR theory. And so it's interesting for me that a lot of those theories use the same words, but it's applied differently in the critical race theory lens. Yeah.
It's really interesting when you have conversation with people in different disciplines. It's really interesting to set your terms early, because I've talked to people in other disciplines, and their definition of realism is very different than it is in the law.
That's exactly the one that I was gonna use as my example. I was like, as you were going through the realism, I was like, no, Reagan was a realist. Why am I like thinking this isn't so bad?
Right. They're different terms. See, I'm a tax guy, so even that. So I'm used to this idea that income to your average person means something different than it means to the IRS, and that means something different than it does to a financial accountant and whatnot. And so this idea that words exist separately in these different genres. I don't know if you're familiar with the concept they call autopoiesis. It's kind of a postmodern collectivist theory of epistemology that each word, even if it has every word is a living thing. Everything is a living thing, including words. And so even if you have something of the same name, we could both be named John, but we're still different people. And that it grows, each thing has a structure, it can see outside of itself, try to defend itself, and also sometimes dies out as well. But that things are collections of discourse, right? And that's their blood and bone, and it's a really interesting thing, but it's one that deals seriously with the idea that the same word has different meanings in so many different contexts. And even if we just put 8 different definitions under one word in the dictionary, we're really talking about 8 different words. No, I think I did go through. Okay, yeah.
Well, no, you're back. Mine's now being weird because we're getting stormed out by me, but
okay.
All I know I'm gonna have, so the idea of like a word, there you are.
Oh, there we go, yes.
Yeah. So I don't know if you heard any of my last little bit, but just to say that this is going to be a fun rabbit hole for me to go down, because I love that idea, the words having like the same word having so many different meanings.
Yeah. Well, who's it? Gunther Twebner, I want to say, is the author that I think I wrote Autopoiesis in the Law. in like the 80s or the 90s or something. Gunther Twebner, I think it's Tuebner or something like that. And then there's also like a theorist called the name, I think, Luhmann, Luhman. And I think he also has written on this idea of autopoiesis of metaphysical things.
Well, good. I will dive deep and go down that rabbit hole and be ready to talk about it next week.
All right. Well, it sounds like fun. I appreciate your comments.
Yeah, no, thank you so much. Have a wonderful night.
All right. Do the same. Do the same.